War on Terror, what's uniqueness, U.S. winning global war on terror, Crystal 2K6, we're winning it, AIDS by far, huge positive troops, Saddam, we're winning war against United States, is extremely important to remove the Taliban government there tonight, United States sanctuary Iran, is time to do everything to take tonight, China to receive nuclear on someone is linked to judicial interference, kills, intelligence, military operations, key to and future attacks, U2K6, the unconventional nature about war, which is Al-Qaeda, more important military interests for because the needs to interrogate enemy combatants in Asian dismiss on primary weapon, the conflict against the two kind of enemy, intelligence will select the needs of fighting future terrorist, acting on U.S. territory, judicial review, in general manufacturers and military effort against Al-Qaeda, he has proceeded, could actually become the form for commanded intelligence officers in the field, in open work shifting operations, military attacks and methods, forcing military ships activity demands of the judicial process court that they have received capacities against the battlefield. If made by the military, the impact terrorist attack would cause world extinction, Saddam and to conform the nuclear attack by terrorists even if fails to further, that's by the negative feature of the new and hiding world mission and living sides which close in on themselves at the extent of human rights that they harm to proliferate, also speed up the oxygen to the United States to the world, or which would not will Richard Torres and nuclear bullshit affect the whole planet will all be losing next office spell, each one is one uniqueness, will win over 12 million, ruling in favor of them, keeping the economy walled by 1132 to record will actually appear to ready to restrain the powerful planet to be combination to claim fail. It's always a right aggressive plaintiff Floyd to justice with even those who normally side with political effort is strictly removed the revenue economy that ever failed to become a criminal benefit opportunity could be sued for an antitrust violation. Yeah, the U.S. economy being legal troubles to bribery, unless antitrust suits are not conflicting against the economy, they're bringing economic and efficiency, mutual competitive contact, exchange that the economy ruling, or the bills are carved political capital, 1127 to the 6 over the court of law, great from left friends, while at the same time reaching back to the footnote, associate general conflict, just specific stand in particular, to anti-justly more difficult court to win 50 years of President Biden and calling in, returning carries cost political courts, really asking about the political capital, sequel to great forward pressure from the administration, carried avoided any performance, call settle or not to settle struggles, things with political range, incredibly factors are venerated, what is like atmosphere, corporate politics, exercise as a virtues, institutional legitimacy, thereby become a position, calculates issue, decidedly different opinions, initiative, because concerns over institutional legitimacy are on score may follow precedent, but does not once again make underwriting its fundamental efficacy issue the court have a radical change those where the communities may be unable to adopt resulting in addition that not producing efficacious role sufficient, or such decision accumulated over time the court will underwrite its legitimacy, universal and additionally economic consequences cause global warfare and 2 cages part of the travel class of the world economy, diesel views everyone, well, everything as fast as it's possible the two causes are 2 million strong than a hell on earth result next off Jackson Bannon Gates appointed uniquely first Bush can lift Jackson Bannon with the amount of capital he has in the statistical medicine on 30 Bush as Thomas Putin in America will reveal Jackson Bannon should underestimate the power of the White House despite Iraq Bush investors so it's supposed to use all that political capital for the years of deal session and goal additionally overall cost political capital vote 99 times Supreme Court decision for national debates that drew and natural participants yes getting conflict involvement only groups with interested benefits influence of the public results from the Congress and involving each decision of one ideological group of political actors and Jackson Bannon generation is the linchpin in which faction wins the debate over the West from ever rise in 2K7 Bush and Putin reached a deal with the Congress and let Jackson Bannon failure with the Jackson Bannon 2 Russian decision to therefore enforcing anti-Western factions and the convincing Russian politicians liberalization so seeing all of which makes the next 6 months the designs of open U.S. Russian history the impacts of the nuclear war goal said and sometimes in 2K5 while Russia will be too powerful to still remain the only country in the world capable of utterly destroying the United States if so if the country does nuclear arsenals in the hands of a dictator then this is indeed a worthy involved with the counterclaim the text of the counterclaim pursuant to the authority under the Hamdan v. Rumsfeld Congress should deny authority to the President of the United States to constitute military commission Congress should enact legislation declaring that detainees are not held in lawful custody for trial before a military commission and the out of oneself case after the Hamdan decision of Bush needs congressional authorization for use of military tribunals on C2K6. The court required in Hamdan the absence of clear congressional permission of some kind of emergency, the commander in chief may not try to secretary of the military commission. The reason can be found in the court in the clear congressional authorization for the creation of military commission in the broad application. And even in the debate in national security precedent with political positions with the Congress is not said and what it has said the court acknowledged the president is the commander in chief now first by the Congress is plenty constitutional authority to the court. Rejected the claim the Constitution gives privacy to the president to protect national security. Even when national security the president may be careful. And to congressional enactments the president is acting in a way they threaten civil liberties or public using the legislative Congress is explicitly authorized for to do that we're not in the middle of a genuine emergency without special congressional authorization tribunals can come forward libertarian leaning 2K6 Hamdan and however, the president could proceed without specific authorization by Congress. So it's basically amounts to statement that unless Congress is going to authorize them to do the and the counterplan is key to check judicial interference, discuss war on terror, and Rican to confirm more important to avoid judicial micromanagement of the war. America's war against the radical Islamic terrorists. The 70 years ago, the court held that the executive branch accepted practice and foreign affairs are granted in unique expertise and neither constitutional choice and expertise and information nor by the president determination to whether we arm in our conflict or win an anti-terrorist cooperation which engage foreign government's current detention, interrogation, policy research can be improved less up to be for the members of political branches of the Congress can debate and resolve in flexible manner of policy, but imperative to individual liberty of America's reputation of success the demands of collective safety too much is already on the outcome of this court to travel western side judiciaries who are unaware of complexities of what is at stake now the independent judiciary. The first answer GOP is undermining the independence of the judiciary through court serving etc. Chief Justice Roberts even supports Pelosi 2K5 ministers menacing towards system of government's ongoing efforts of Congress to violate separation of powers and taking away the courts to decide which case they can hear court serving is dangerous under courts to be denied the ability to review certain claims affecting individual rights or access to Congress constitutionally replicable competence on constitutional bills and ensure that there would be no right court to review the court serving or violence for principle judicial review. There's been such a picture of American government 200 years from Ghost of the House, the House of Research, Roberts actually condoned course stripping efforts in the ICN, especially those interested in constitutionalism and the critical states model, France model, 2 states, Middle Eastern constitutional laws predominantly follow the French political science government model and more constitutional scrutiny, and its American form. Eventually, you won't win a uniquely millions of emergency powers are inevitable in the current environment. Sherman, 2 states, first advantage of the tackle a host of often talks on precedent, political, military, economic health, some which are the both major threats that exist in the political legal order, apparent avoidability, social ubiquity of emerging the executive authority, essentially minimize rule of law, demonstrate powers of and confer enough authority to rule this country without reference to normal constitutional process. The internal link is inevitable. You can't solve it using the rule of law. Sharman 2K6. No legal norm has been satisfactorily contained or effectively regulate emergency power legal. Nor is emergency power simply not accept that it remains impossible to codify emergency purpose. Every attempt to provide a statutory constitutional basis for their exercise necessarily works to normalize problematic forms of emergency power. Emergency inevitably is in the confines of any legal norm. Poison legal system as well. And judicial modeling cannot be the answer. The U.S. has always had inconsistent rules in emergency. Sherman 2K6. U.S. model of judicial oversight never works well. You will any health elections over during wartime in U.S. history leaves not to be desired. The infamous core monster ruling has never been formally overruled. The fact that it's begun to matter. However, 11th, you do not solve the Center for Justice and Accountability evidence. Your affirmative doesn't ban the war on terrorism or ban Guantanamo Bay or stop human rights violations in general or get rid of the USA Patriot Act. In addition, the status quo continues the Millennium Challenge Aid, which provides the incentive for countries to continue modeling us. And Kieran itself would have been a unique internal link to your story for the past 40 years if your story made any sense. Why would there be any independent judiciaries in the world post the Kieran decision if Kieran is the unique link? Plus, the NAFTA tribunals are actually the biggest threat to U.S. and judicial independence. New York Times 2K4. Under the NAFTA agreement, the government whose court system is challenged for warside tribunals, so this is the biggest threat to the United States judicial independence. And there's a long-standing link between democratization and nationalist war is not diminishing some democratization, raise the likelihood of war bans failed in Center 2K6. There's no reason to believe that the link between democratization and nationalist war is diminishing. Many countries on the bills of the democracy approach, like the institutional infrastructure needs to match the early stages of democratic transition. Fourth wave would involve countries that are poor, more ethnically divided, more in outing more resistant to democracy with more entrenched authoritarianism and a much frailer by basic governmental institutions and citizen skills. Now, the soft part of A first answers that multiple alternate causality of soft power is plan A point torture obliterates U.S. moral soft power, character prospect 2K6, the U.S. with soft power. Won't take seriously anymore, but just comes in America's not torture. When America seems a nation responds to despair to torture, Al-Qaeda twisted arguments gaining credibility inside the United States, and the Iraq War negated the effectiveness of U.S. soft power. Other countries are filling in council with foreign relations. 2K6 U.S. culture bans through films and books and other media reigns dominant worldwide. Washington's lose ability to win allies through soft power. It's very difficult for U.S. soft power to get people that are engaged in an active economy. Says European soft power efforts are focused on democracy, promotion, and rejection of numerous issues and multilateralism. Crushing soft power, political science, quarterly 2K5. Nazi uses the current administration squatting U.S. soft power, using unilateral approaches to its own power applies attacks in the UN and the other international institutions invites rejection. Such popular initiatives as the Code of Protocol and the ICC. He is correct. Necessary exercise military economic power. Never mind. Asian soft power is meaningless and resilient. It can't be manipulated. And U.S. culture provides a floor to soft power. Collapse political science quarterly 2K5. The source of soft power include Asian about the size of individual behavior, access and dominant culture, taste through the commercial activities, Hollywood movies, for example, the personal context, nation policy, soft power, and integrated power can be deployed in specific situation. One that can be shaped into being employed by the government's soft power system, may be influenced by governmental trust, but it's more of an existential plan for the policy environment, something, and also makes you utilize the orientation charge to others is not a factor that can be exploited in any coherent way. Additionally, yeah, U.S.-Europe relations are resilient and restored. Ashashi Boost have chapters on defense to exist, so became clear as a resilient on 2003 transformative post the United States since then relations have been restored. NATO serves as the foundation for U.S. military, Europe military alliance, and structural change risk we track through the disability of U.S. contracts. Relations alliance relations between the U.S. and Asian countries tend to be more unstable. Will not even answer their AIDS argument. The cross-stakes of standing enough on this particular question. They don't have any evidence to actually quantify what is necessary in order to achieve AIDS. Human rights leadership. Or international law, sorry. The planned imposition of values like democracy and human rights will be deployed in a coercive way by neoconservatives, negating the positive effect of producing. Actually, no, that's not it. We will beat you with one card. Either A, the recent enemy combatant cases solve your advantage, or B, they prove that even post the plan, the justice won't move towards accepting international law consistently. Journal of Conflict and Security Law 2K5, the Supreme Court increasingly refers to international law sources, including the enemy combatant case, and may signal that it is preferred to engage with legal development concerns of the U.S. or alternatively it seeks to limit the relevance of such developments to the U.S. legislation, particularly in the Russell case. International law would offer strong arguments in support of the court's finding. Nonetheless, there is not a single reference to international legal sources to be found in the whole of the Supreme Court's majority by accepting the dating name on a basis of line of reasoning are anchored in U.S. law to simply not find a necessary attention to a discussion of international law. Military tribunals are compliant with international law. Belky in June has been over 2.5 years of debating military commission procedure. Developing the military commission so that it's just in complete compliance with contemporary U.S. and international law. Additionally, international law doesn't solve the laundry list on army law 2K7 and domestic society violators of your rule of law do not have authority to how the violation of forcing the international system. There's simply too many bad actors that have a say in the enforcement make it the application possible or practicable in the domestic society. So redress in the form of additional Peter the international system lacks that very basic inducement ability. In other words, as such, much false and violative international law says yeah, and most international laws, aspirational enforcement is apart. Your proposition states are rarely punished, mostly in many cases, actually maybe not depends on any wrong consistently flat treaty obligation with an area race platform for international laws. Only the most recent evidence why the rule of law simply does not exist in the international system.
Alright, what's the status of the counter?
It's dispositional.
What does that mean?
That means if you make a permutation or a theory argument aside from dispositionality is bad, then we have the right to kick it.
Okay, is the war on terror, does that net benefit to this?
Yes.
Why?
Because we have two pieces of evidence. The link evidence in the war on terror shell and the Bork and Rifkin evidence on the counterplan indicate that it's judicial interference that is the unique threat to the war on terror. For instance, the inability to conduct interrogations is negated by when the court has the ability to seize upon the case. our evidence is all specific to judicial interference.
Okay, your counterpoint text says that Congress should deny authority to the President of the United States to constitute a military commission, which is what Hamdan did anyway. It said that Bush's military commission that he established was illegal. And it says Congress should enact legislation saying that detainees are not held in lawful custody for travel for a military commission. Where does this say, what about the MCA?
What about the Millennium Challenge Aid?
I mean, obviously, it would supersede any authorization.
Is the MCA the Millennium Challenge Aid? What do you mean? How would this supersede this?
You're talking about the Military Commissions Act, sorry. I was thinking of the Center for Justice and Accountability evidence. What about it?
If Congress can ratify and create its own military commission system, which it did after Hamdan, because your counterpoint
it denies authority to do that, and it says you can't. It says you can't hold those people.
How would this solve the case if it's proven that not just several months ago Congress created a military commission?
Because Congress, that was not the creation of an independent congressional system. That was authorization for the president to constitute those trials under the Military Commissions Act. Functionally, the counterplan repeals that. It says the president doesn't have the authority to do it.
Okay, let's talk about your Waldner evidence, which is your uniqueness on Bell v. Trombley. The reason why it says it creates, why it's key to solve the economy is because of meritless antitrust suits. What's the threshold on meritless antitrust suits that are going to kill the economy?
Actually, I mean, there doesn't even have to be that many antitrust suits. The point is actually the perception. If those companies really think that they're going to be... there are two links, right? One is that if they think the antitrust suits even exist, then that essentially creates a chilling effect.
I don't know exactly what the threshold is for how many suits, but I know that it is less than half of the economy, which is what our evidence says.
It's less than half?
Probably less than half of the economy. Our evidence indicates half the economy would be involved in an antitrust suit in a world where Twombly wins. So probably the threshold is less than.
Let's talk about your Siegel evidence. This says that overturning Karen would cost the court massive amounts of political capital, and then gives the historical analogy of in 1942 when Roosevelt, who was more popular than Jesus, passed his commission. The court didn't want to challenge him. Where does it say this would even be analogous to today's court environment or the political environment?
That piece of evidence takes that example and says if the president explicitly tells the Supreme Court,
you don't think that Karen would have been a unique circumstance in the fact that if they had opposed Roosevelt, he would have packed the court?
No. Well, I see where you're getting at, but I don't know why this is much of a different situation. Well, Bush comes out and says,
your
praising liberal justices, war on terror,
is really just, if we'd done this in 1942, it would have been bad for political capital. Where does it say
that's the empirical warrant? It makes an analogy to the present.
And I want to know why this is analogous to today's environment.
Because there's support for military tribunals.
And if the president says so.